Hello everyone, my name is Anurag Singh. Welcome to Pahuja Law Academy. And in this video or in this lecture, I am going to give you an overview of the code of civil procedure, right? So let's start. The code of civil procedure. Okay. So the first thing you need to understand is the importance of CPC. The laws are mainly divided into two categories, that is civil as well as criminal, right? Now, under criminal law, the subjects that we study are limited to IPC and CRPC, right? That is the limitation of criminal law. They are limited to IPC and CRPC. Almost every other subject that we study will fall under the civil law. It can be contract, or it can be the Transfer of Property Act, or it can be Hindu laws, or it can be Muslim laws, or it can be company law, or it can be labor law, or it can be the Sale of Goods Act, tort, partnership, registration, limitation, IPR, etc. Almost every other subject that we study falls under the civil category, right? So we can comfortably see that civil is a vast majority of the subjects. So 90% of the subjects, they come under the civil category. So, and to regulate these 90% of the subjects, there is only one code, which is the CPC, the Code of Civil Procedure, right? So immediately you can see the importance of CPC from an understanding point of view, that you want to understand law, you must be thorough with the CPC because it regulates 90% of the laws, right? Now, apart from the understanding point of view, if you look at the examination point of view, from the point of view of the judicial services examinations, they go at the prelim stage, you will get somewhere between 15 to 20 questions from the Code of Civil Procedure. This is considered as a major subject, or yahan par you can easily expect 15 to 20 questions, right, in the prelims examination. In the mains, at the main stage, you will get there will be a separate paper for procedural law. Most of the examinations have a separate paper for procedural law, and in this you get questions from CPC, the CRPC, and the Indian Evidence Act, right? So even in the mains examination, you can see that 1/3 weightage is still given to the CPC. Not only this, but in some mains exam, not all, but in some mains exam, you will have to write the plaint, you will also have to write the written statement, and in some exams, even the judgment writing is going to be there, right? So remember, you will only be able to write the plaint when you are thorough with CPC. You will only be able to write the written statement when you are thorough with CPC, and same is the case with judgment writing. So for all these, you would need CPC. So not only from an examination point of view, but also from an understanding point of view, CPC becomes a very important subject for you to study, right? Right. Now, to understand the importance of CPC, that's a comparatively easier job, because we can see 90% laws को regulate करती है CPC. And the other part is, from an examination point of view also, CPC is a very important subject, right? Now, but the real question is, how do we study CPC? Because if you don't know the proper way to study CPC, it can be really confusing. So to understand CPC, the first thing we have to do is to divide CPC into two parts, right? To understand CPC, we have to divide into two parts. And those two parts are, the first part is the sections, and the other part is the orders, right? So we have to divide CPC into sections and orders. Now, what are sections and what are orders? Those sections give you the general principles or the broad framework, right? They never go into details. There will be no details in the sections. Orders, on the other hand, these are deemed as the real elaboration of proceedings. Real elaboration of proceedings. And this is the place where you can find the details. So just remember that to understand CPC, you need to divide it into two parts, that is sections and orders. Sections give you the principles of the framework without the details. If you need the details, you will have to go to the orders because they are deemed as the real elaboration of proceedings. Right? Now, the other thing that you must always keep in mind is for almost every important section, there will be a corresponding order. So almost every important section will have a corresponding order. So the question was, what is the proper way to study CPC? The proper way to study CPC is you study the section and then directly jump to the corresponding order. That is the proper way to study CPC, right? Kaise? Study the section and then directly jump to the corresponding order, right? Do not study CPC section wise or order wise. Do not go through CPC in this manner. How do we go through CPC? We go through the section and then we go to the corresponding order. That is the proper way to study CPC. Now there are many examples in CPC where a section has a corresponding order. I will just list out some of the examples. Now suppose we are studying the topic of institution of suits, right? For this, we need section 26. For the topic of institution of suits, we need section 26 and the order is order 4, right? So after section 26, we directly go to order 4. We do not go to section 27. Okay, okay, all right, students, just let me know. Ansh, Bhanvi, Debayan, Jasdeep, Raghav, Ranveer, Ananya. Have you done CPC? Have you studied CPC? Just write a yes or no. Just write yes or no. Have you done CPC? Have you studied CPC? Okay. Okay. Some have covered it. Okay. Those people who have covered it, if you have the Bare Act, can just check this out. Okay. Just take out your Bare Act and you can just see section 26 का corresponding order है order 4 and the topic is institution of suits, right? Now suppose we are studying the topic of summons. So for summons we need section 27 to 32 and the order is order 5, right? Again, do not go section wise or order wise. Go through the topic, go through the sections and then directly go to the corresponding order. Here we also have order 16, right? So for summons we need 27 to 32 and the order is going to be order 5 and order 16. Now suppose we are studying the topic of judgment and decree. So for this we need section 33 and the order is order 20. Again you have to follow the same thing. Study the section, then directly go to the corresponding order. Now suppose we are doing the topic of costs. For costs we need section 35 and 35A and the corresponding order is going to be order 20A. Right? Same thing, I'm just giving you a few examples. Now suppose we are studying the topic of execution. So for execution we need sections 36 to 74 and the order is order 21. Suppose we are studying the topic of, let's say, first appeals, right? So for first appeals we need sections 96 to 99 and the order is order 41. If we are studying the topic of second appeals, so for second appeals we need sections 100 to 104 and, sorry, 103, not 104, 100 to 103, and the order is order 42. If we are studying the topic of appealable orders, so for appealable orders we need section 104 and the order is order 43. If we are studying the topic of, let's say, reference, so for reference we need section 113 and the order is order 46. If we are studying the topic of review, we need section 114 and the order is order 47. Right? If we are studying the topic of, let's say, commissions, so for commissions we need section 75 and the order is order 26. We are studying the topic of temporary injunctions. For that we need section 94C and the order is order 39. If we are studying the topic of receiver, for that we need section 94D and the order is order 40. Okay. If we are studying the topic of interpleader suits, for this we need section 88 and order 35. If we are studying the topic of out of court settlement, then we need section 89 and the order is order 10, rule 1A, 1B. Right? So I just give you a few examples where a section is going to have a corresponding order, right? So always, how are we going to study CPC? We are going to study the section and then we are directly going to jump to the corresponding order, right? And the proper way of doing it is this way, because the section only gives you the principles of the framework. There will be no details. The details are always going to be in the orders, because orders are deemed as the real elaboration of pleadings, right? But one thing you should keep in mind, although this is a very good thing to do, where you study the section and then go to the corresponding order, but that does not mean that you can pick up any random section and go to the corresponding order. No, that is not the proper way to do it. Although this is a good thing to do, but even this must be done in a way that it makes sense, right? So the fundamental question that we need to ask is, how does an ordinary suit run? Right? Upon the answer of this question, what we are going to do, we are going to make a timeline, a very basic timeline of how does an ordinary suit run. Okay? So how does an ordinary suit run? How does a suit start? Anyone? All students, anyone? Ansh, Bhanvi, Devayan, Kasdeep, Karishma, Newman, by filing a plaint. Very good. Section 26(1) says, every suit shall be instituted by the presentation of a plaint. So the first thing that happens is by filing a plaint. So that's how you start a suit. The plaintiff comes to the court, files his plaint, and that's how a suit starts. After the filing of the plaint, what is the second step? Now the suit has been instituted. What is the second step? Notice, and that's called as Newman. I don't know if that's your real name, Newman Law Office, but I'm not your username. Notice to the other party is called. What is it called in CPC? It's called as summons. Right? So after the suit has been instituted, the other party is served with a summons, which is basically a notice to the other party that a legal proceeding has been initiated against you. Right? Now, the other party, what it does after this, after the service of summons, the WS is filed, then the other party files a reply to the plaint. That is known as the written statement, right? Now, after both parties have given their written submissions, then the next step is appearance and examination. Appearance and examination. This is an oral examination. याद रखना, many times what is going to happen is the parties, the language that the parties have used in their respective written submissions in the WS and in the plaint, the parties wanted to give it a different meaning, but the court is getting a different meaning, right? So the court would want clarification upon that particular point, and that is why the court asks both of them to appear and examines them orally, right? So, याद रखना, after the parties have given their written submissions, the court asks both the parties to appear and then conducts an oral examination. Now, after this, the court is in a comfortable position to understand what is the real nature of dispute, what is the real dispute between them. And that is why after this, the court goes up to framing of issues or the settlement of issues. Right? Now, after the issues have been settled, the next step is trial. Right? Now, the trial ends with a judgment and decree. Right? At the end of the trial, there will be a judgment and there will be a decree. Now, the question is, does the suit end there? Now, does the suit end there? After the passing of the decree, has the suit ended? The winning party would like to go for execution. Yes. After the decree has ended, the winning party would like to go for execution. But what about the losing party? क्या करेगा बताओ? Yes, very good. The winning party would like to go for execution, but the losing party would like to go for appeal, or he can go for review. Revision in some cases, but not always. Most appropriate is review. Okay? And then lastly, if the decree is questioned upon the ground of jurisdiction, only then can a revision be filed. Okay, so always remember this, that this is the step-by-step procedure, a very basic timeline, but still to have you that mental frame ki this is how an ordinary suit runs, right? Now the next question is, why do we need to make this timeline? देखो, summons, देखो यहाँ पर plaint is in order 7, summons is in order 5, written statement is in order 8. यहाँ पर if we look at the sequence, and I need to for a second. I don't see why did you point out section 105. Yes, that is exactly what I said. I said that in case of the decree, the losing party would like to go for appeal or a review. But if you have to question the decree upon the ground of jurisdiction, that is exactly what it says. If you have to refer the decree upon the ground of jurisdiction, then you can go for revision, otherwise you can't. So the point here is key, we need to, why do we need to make this timeline? Because if you look at the sequence of CPC, what it does, CPC has served the summons under order 5 before even the topic of plaint is brought up in CPC, right? So we know that this cannot happen until the plaintiff comes and files his plaint. There can be no service of summons, right? First thing. Second thing, in summons order 5, the rule 2 of order 5 says that every copy of summons shall be accompanied by a copy of the plaint. That means a plaint has already been filed, because if the plaint has not been filed, there cannot be a copy of the summons, right? So we can see that CPC is not arranged in a way like an ordinary suit runs. That is why this timeline is to be made by us. We have to make this timeline, no, right? अब देखो इसमें plaint order 7, this has to be read with section 22 and order 4. Then we have summons, this has to be read with section 27, read with order 5. Again, execution, sections 36 to 74, this has to be read with order 21. Again, judgment and decree, this is section 33, read with order 20. Appeal, this is sections 96 to 99, read with order 41. Review, this is section 114, and this has to be read with order 47. Revision, this is section 115. This section does not have a corresponding order. Appeals and examination, this is order 9 and 10. Framing of issues is under order 14. Then we have the trial under order 18. Okay. देखो, this is the basic timeline by which you should study CPC. Okay? And so the thing that I said in the beginning, that you should always keep the section or order correspondence in mind. Yes, that's a good thing, but don't pick up any random section and go to the corresponding order of that section. No, you have to arrange the whole of CPC on this timeline, and then you should study the sections and then the corresponding order, then the sections and the corresponding order, then sections and the corresponding order, sections and the corresponding order. That is the proper way to study CPC, right? So far, do you have any questions, all the students? Do you have any questions? Idhar, Elika, Aranya, Kya, Ranveer, Nalen, Karishma, Jasdeep, Bhanvi, Ansh. Oh, okay. Chalo, so let me just give you an overview of CPC, right? How does an ordinary suit run? I'm just going to give you an overview of step by step this procedure. Okay? So let's start with a plaint. Chalo. What are the statements which are necessary in a plaint? Can anyone tell me what are the statements which are necessary in a plaint? A plaint is divided into 3 parts. Okay. A plaint is divided into 3 parts. The first part is the facts of the case, which contain things like name and description of parties, right? Then we have, if there is a property involved, you also need to give a description of Right. Yes, yeah, good point. But abhi nahi, not now. Sorry, some problems in the mic. So you have to give the facts of the case, the name and description of the parties, and if there is any property involved, you also need to give the description of the property. And lastly, there will be the cause of action. Cause of action is basically the reason for the filing of the suit. Now, this is just the first part. The second part is technical pleadings. Technical pleadings like limitation, jurisdiction, and valuation. Okay? So suppose there is no problem in the facts of the case, but if the suit is outside the limitation period, the court is going to say that the suit is not maintainable because it is barred by limitation, right? So you have to show that the suit is maintainable, right? It is within the limitation period. Now, let's say the suit was within the limitation period, but it was supposed to be filed in Chennai and we are trying to file it in Guwahati. So the Guwahati court is going to say that I don't have jurisdiction in the case. So you have to show those facts which are which show that the court has jurisdiction. याद रखना that technical pleadings are always related to the maintainability of the suit. Maintainability of suit, right? And lastly, as Sia rightly pointed out, that there must be the relief, which is in the form of a prayer, also known as the prayer clause. And in the prayer, the court, the plaintiff actually asks for the remedy. Okay. Yes. Yes, Niman, bilkul. It would include the pecuniary jurisdiction. And the purpose of valuation is twofold. One of them is pecuniary jurisdiction, as Niman said. Yes, bilkul correct hoga. The first is pecuniary jurisdiction. What is the other one? Niman? I don't know if that's your real name, but what is the other purpose of valuation? Court fees. Bilkul. There are two aspects to valuation. One is court fees and the other one is pecuniary jurisdiction. Now this would what a basically plain would look like. Now the second step is summons. Now let's see what is a summons. Summons are a notice given to the other party that a plaint has been filed against you, right? So yaad rakhna, summons jo hai, it is the fulfillment of the principles of natural justice. In the principles of natural justice, we come across the term, this is two elements hote hain. The one element says that the other side must be heard, or an opportunity must be given to the other side of being heard. So how do we ensure that opportunity? By serving them summons or by serving them notice, right? Now, in order 5, yaad rakhna, order 5 has 30 rules. Okay? You don't need to study all the 30 rules, you have to study the 20 rules. Jo starting at 20 hai, wahi padhna. End of the 10 you can ignore because they are very specific, right? Now, in this, the breakdown, here we have under order 5, rule 1 to rule 8 of order 5, they are very basic rules, right? They give you what should be the contents of summons, right? And who signs the summons, right? Who court seal, and what is the distance in which the summons can be served, is there is a limit to it. All of that is in rule 8. In fact, order 5 ka rule 5, it says that the summons shall be served twice. Look, we have this misconception that every time a party is asked to appear in the court, they will have to serve with the summons. No, that is not the case. A party is asked to appear in the court only twice. The summons are served upon the party only twice. One is for the settlement of issues, and the other one is for the disposal of the suit, right? For the final disposal. In order 5, rule 5, if you have the barrack, go to order 5, rule 5, summons are served only twice. So order 5, rule 1 to rule 8, it's a very basic one. यहाँ पर basic rules ही होते हैं, right? Then उसके बाद हम लोग देखते हैं service of summons, जहाँ पर की rule 9 and 9A, ठीक है? This is service by the court and by the plaintiff. Service by court and service by plaintiff. Okay. Now, like now, the court has its own officers, or it can also engage the services of any courier agency, and then it can ensure that the summons have been served upon uh, the defendant, right? Or the plaintiff can also serve the summons upon the defendant. But yaad rakhna, whenever the plaintiff is asked to serve the summons, it's not that only plaintiff will serve. The court will also serve, and this one is actually in addition to what has already been given, right? So service by court and service by plaintiff. The court will serve its summons, and in addition to that, the plaintiff may apply for the service of summons. Now, this is service by whom? It can be done by the court or it can be done by the plaintiff. Now, upon whom? Upon whom the summons is going to be served? That part is service upon the defendant personally, right? Now, in rule 12, 13, and 14, this is service on defendant personally, right? Then we have rule 15, which is service on defendant's family, also known as extended service. Okay. Then we have rule 16. I'm just continuing that in the next slide. Rule 16 and 18, that if the defendant is not found, we try to affix the copy upon his property. So affix a copy of summons on defendant's property or his house. Right. Even after this, if you don't find his house, rule 20 is substituted service. Substituted service, right? This is where the advertisement is given in a newspaper. Advertisement in a news. Okay. In addition to the copy of summons being affixed in the court premises, you can also give advertisement in the newspaper. So all of this is for the service of summons, right? Just to give you an overview of summons. Then, after the summons have been served, next we have the written statement. Okay? So written statement what is a written statement? Anyone? What is a written statement? Anyone? What is a written statement? कोई बताएगा? All the students? Anyone? Okay, very good. Why is only one student replying? ये एक ही student क्यों reply कर रहा है? And what's your good name? I don't know, because it says Newman Law Office. What is your name actual? I know you are the only one replying. Karan. Okay, Karan. Why? I understand that, Karan. It's okay. I'm not saying you should, but why is no one else replying? Nobody else is. Okay. कोई और reply नहीं कर रहा है. I don't know. चलो ठीक है. Written statement. It is basically a reply to the allegations made in the plaint. Karan is 100% right, but he is half correct. It's a reply to the allegations made in the plaint. Bilkul true. Reply to the allegations made in the plaint. Now, reply to plaint. Now, that reply can be a denial, or it can be an admission, or it can also be silence. Maybe the defendant does not deny it. He does not deny it. He does not admit it. He is just silent upon that point. This will be deemed admission. Okay? So, a defendant can deny the allegation made in the plaint. He can also admit it. He can also remain silent. But if he remains silent, it will be deemed as admission. But that is only one part of the plaint. The defendant can also raise new points like set off, or he can also plead counterclaim, or he can also plead others like a bar of order 23 rule 3, or he can also say the bar of order 2 rule 2, or he can also say a bar of, let's say, section 11 res judicata, okay, and etc. बाकी भी हो गए, यहाँ पर बहुत सारी चीजें हो सकती हैं. So when Karan said कि basically reply to the plain, that was true for the plain part. But याद रखना कि a written statement does not need to be limited to the allegations made in the plaint. It can also be new points, जैसे कि set off plead कर सकता है, counter claim plead कर सकता है, on all the other things. यहाँ पर set off जो है, written statement is in order 8. This set off is in order 8, rule 6. Counter claim is in rule 6A to 6G. Order 8, rule 6A, that is counter claim. Okay? So written statement में याद रखना, it's a reply to the plaint, but will also contain new points. Right? Chalo. Just to give you an overview of written statement, now we have the next step as appearance and examination. Right? देखो, the court will ask both the parties to appear and it will examine them orally. So for appearance, okay, देखो appearance में both parties must appear. The plaintiff and the defendant must appear. But order 9, यहाँ पर देखो appearance and examination, that is order 9. Order 9 is actually not limited to appearance. The main part of order 9 is what are the consequences of non-appearance of a party. याद रखना कि order 9 says both parties must appear, plaintiff and defendant. What if one of them does not appear, right? What are the consequences then? Suppose the plaintiff appears and the defendant does not appear. What happens then? क्या होगा तब? Anyone? This is a fit case for taking up ex parte proceedings. Karan, don't go to ex parte decree. Right? Ex parte decree नहीं पास होगी, तुरंत नहीं पास होती. That's a misconception. To go for ex parte proceedings. Okay? In that, ex parte decree can be passed. Okay? So at the first hearing, the court will order for the ex parte proceedings, which can later on go to ex parte decree. Right? अब यहाँ पर Karan, if you have the bare act, go to order 9, rule 7. If you have order the ex parte proceeding, this is order 9, rule 6, in sub-rule 1, clause A. Order 9, rule 7 actually says, in the ex parte proceedings, if the defendant appears and he shows good cause, then the ex parte will be turned into by party. Right? Go to order 9, rule 7. Karan, एक बार check करना बेटा वहीं पे है. Okay? So the plaintiff appears and the defendant does not appear. That's a fit case for ex parte proceedings in which ex parte decree may be passed. But what if the opposite happens? अगर opposite हो जाएगा तो क्या होगा? Suppose the plaintiff does not appear and the defendant appears. यहाँ पर क्या होगा? Anyone apart from Karan? देखो यहाँ पर the first instinct that we should answer, or we are likely to answer, is that the suit is going to be dismissed. Yes. Yes, that should be the first. Karan, मैंने कहा कि first instinct हमारी यही होती है कि dismissal of suit होगा. But what if the defendant appears and he admits? Right, Karan, is this possible? If the defendant appears, but he admits to the allegations made in the plaint, now the suit will not be dismissed. Right, Karan? Now, देखो, then a decree will be drawn. Exactly, that is my point. कि कभी भी आप ऐसा मत बोलना कि if the defendant appears and the plaintiff does not appear, then the suit will be dismissed. No, if the defendant appears and he denies all the allegations made in the plaint, then the suit shall be dismissed. But if he admits it, then the suit is decreed. Okay? याद रखना, defendant appears, वहां पर हम लोग को देखना है, if he denies, suit dismissed, he admits, suit is decreed. What if he partially denies and partially admits? अब क्या होगा करण? Since nobody else is answering, let's you're right. So for the admitted part, the decree will be passed, and for the denied part, the suit will be dismissed. Okay. याद रखना, this is just to tell you कि order 9, this is all order 9. You can see order 9 में rule 6 हम लोगों ने ये वाला किया, this is order 9, ये वाला. Expirative proceeding, this is order 9, rule 6. Then order 9, rule 7 में, if the defendant appears and he assigns good cause, ex parte will be turned into by party. Okay. Then order 9 में rule 8, 9, ठीक है, यही है. ex parte डिक्री को अगर सेट असाइड कराना है, that is rule 13. ex parte decree to be set aside, that is order 9, rule 13. Okay. Meaning of by parte. Karan, what do you mean by ex parte? Just tell me, what do you mean by ex parte? That's the situation of ex parte. What is the literal meaning of ex parte? Literal meaning of ex parte? You don't know. Okay, it's very simple, Karan. It's very simple. Ex parte means one party. The literal meaning of the term ex parte is one party. Right? One party decree. And then when the defendant appears, then the ex parte proceedings are turned into by party. That means both parties are there. चलो. This is just to give you an overview. अब याद रखना एक बात और, यहाँ पर जो एग्जामिनेशन होता है, what is the purpose of examination? This is an oral examination. देखो यहाँ पर मैंने लिखा है that an oral examination happens, right? Appearance हो गया, अब हम लोग को देखना है oral examination. What is the purpose of the oral examination? Order 10 है. This is order 10. देखो, there are actually two purposes. First purpose is the court wants to confirm the admissions and denials. Admissions and denials, right? So whatever the admissions have been made in the WS and the allegations have been made in the plaint, उन सबका admission या denial जो होगा वो court confirm करेगी दोनों parties से, right? And the other purpose is the court will look for the answer to the question, is ADR possible? Is ADR possible? What do you mean by ADR? Anyone? What do you mean by ADR? Exactly. ADR is alternative dispute resolution. Okay? So when the court has confirmed the admissions and the denials, it will also look at the question, is ADR possible between the parties? If the court, now this question will be answered in two ways. One, the court will come to the conclusion, yes, ADR is possible. This is a fit case for ADR. Or the other one is, this is not a fit case for ADR. If ADR is possible and the court comes to the conclusion, yes, ADR is possible, then the next question the court is going to say, which mode of ADR is suitable? Which mode of ADR is suitable? Right? Because we have different modes of ADR. We have arbitration, we have conciliation, we have mediation, we have lok adalats, we have negotiation, right? And we also have other kinds of like judicial settlement, वो सारी चीजें हमारी हैं. So the court is going to say which mode of ADR is suitable. It can be arbitration, or it can be conciliation, or it can be mediation, it can be negotiation, it can be lok adalat. Okay. Or it can be also, let's say, judicial settlement. Okay. If the court is convinced that ADR is possible, then it will decide which mode of ADR is suitable. and then according to that, it will send the parties to that mode of ADR, which the court thinks is the most suitable one. But in arbitration and conciliation, the court can only send them if there is a consent of the parties. Without the consent of the parties, the court cannot send them for arbitration and conciliation. In mediation, lok adalat, and judicial settlement, the court can send the parties to for mediation even if there is no consent of the parties. If ADR is not possible, then the next step is framing of issues. Now the court will go to the next step, which is the framing of issues. Okay, and that is our next topic. यहाँ पर देखो, after the court has examined them orally, and the court thinks that ADR is not possible, then we go to the framing of issues. Right? Framing of issues. देखो, issues are something which everybody understands, but whenever you are asked the question, what is an issue, most people do have a tough time defining it. Issues. What are issues? Issues arise when one party affirms and the other party denies. Right? Right, exactly. Issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. If you have the Bare Act, go to Order 14, Rule 1. Order 14, Rule 1. Issues arise when one party affirms and the other party denies it. Okay? So there can be two kinds of issues. There can be issues of law and there can be issues of fact. Right? Karan, can there be a third kind of an issue? Issues of law and issues of fact ke alawa? No. A mixed question of fact and law. Mixed question of fact and law. So just look at the example. So suppose the wife alleges that the husband has mistreated me and that is why I am entitled to maintenance. That is something the wife is affirming or she is alleging, right? Now the husband has two ways of replying to this. The first way of replying to it is the husband admits to whatever the allegation is made in the plaint by the wife, right? So if the husband admits it, then there is no issue. Issue tabhi arise hoga when the other party or the husband here denies it. If the husband says that I have not mistreated her and I will not pay maintenance, then the issue will arise. The issue will be whether the wife is entitled to maintenance, or the other one is going to be whether the husband has mistreated the wife, right? There will be actually two issues, whether the husband has mistreated the wife or दूसरा वाला होगा हमारा whether the wife is entitled to any kind of maintenance. याद रखना, issues तभी arise होंगे when one party affirms and the other party denies. Okay, that is the part. और यहाँ पर there can be issues of law and there can be issues of fact. Now, after the issue, we go to the part where we have the trial. Now the trial is basically in 3 steps. Okay? The trial. सबसे पहले, the plaintiff produces his evidences. Okay? It can be oral evidence, it can be documentary evidence. Then after the plaintiff has discharged his burden of proof, then the burden of proof shifts upon the defendant, and now the defendant produces his evidences. Okay. The defendant produces his evidences, and then at the end there will be arguments. Okay. Not always, sometimes the arguments happen. Civil में the arguments rarely happen. Not really, not that frequent. But civil में भी arguments हो सकती. So one party gives his evidence, the other party then gives his evidence, and then there are the closing arguments. Okay. Now this is Section 101 of the Indian Evidence Act. This is then Section 102 of the Indian Evidence Act. Okay, the burden of proof. Okay. So both parties will give evidences. और यहाँ पर याद रखना मैंने evidences term use किया है. This can be documentary evidence and oral evidence. And same goes for the defendant too. Evidences can be oral or documentary. Okay. So that's the process of trial. And at the end of the trial, there is going to be a judgment and a decree. Okay. So judgment and a decree. अब देखो, judgment is a process. यहाँ पर देखना, it's an end process. It's an adjudication. An adjudication. What is an adjudication? There is a process to determine the rights and liabilities of the parties. To determine the rights and liabilities of the parties. That's the adjudication. And the final statement, which actually points out the rights and liabilities of the parties, that is known as a judgment. Okay? This is the final statement. That's the judgment. This conclusively says which party is liable and which party's rights were violated. Right? Then finally we have the decree. Okay? So, the judgment is usually followed by the decree, because after the passing of the judgment, within 15 days time, a decree must be made, right? A decree must be prepared. So decree is the operative part of the judgment. Okay, it is the operative part of the judgment. The judgment is merely a statement of who's right and who's wrong. Suppose A owes money to B, that's the part of the judgment. But how is A going to pay that money? How much is to be paid? When is it to be paid? Who pays it to whom? If the money cannot be paid, is there any other way that it should be paid? All of that is in decree. That is why decree is known as the operative part of the judgment. And it is not the judgment which is executed. It is the decree which is then goes on to execution. Okay. Now, the decree is executed, but yaad rakhna, after the decree is passed, there are two courses of actions possible, right? Decree is passed, two courses of action. The winning party would like to go for execution, but the losing party would like to go for an appeal. Okay? So execution. Execution is the enforcement of the decree. What is execution? The decree has to be enforced or implemented. So execution is the enforcement of the decree or the implementation of the decree or the implementation of the decree. Right? Now there are many modes of enforcing a decree, right? That is given also in the sections, but you should remember one particular rule, that is Order 21, Rule 11, Sub-Rule 2, Clause J. Okay? और इसमें you are going to see Clause J में 1 to 5. Okay? These are the different modes of execution. If you have the Bare Act, you can see number 1 is by the delivery of specific specific property, or by the attachment of the property, by the sale of the property, by the attachment and sale of the property, by the appointment of a receiver, or any other kind of, as a decree, any other kind, any other mode which the court may deem fit in the current scenario of the case. Yep, yaad rakhna, that also depends. Mode of the execution of a decree is decided by mode of the execution of the decree decided by not the not the court, but it is decided by the plaintiff. Sorry, plaintiff, the decree holder. Okay, it is the decree holder who decides what is going to be the mode of execution of the decree. Okay, just to give you an overview, modes of execution, yaad rakhna. Order 21, Rule 11, Sub Rule 2, Clause J, and then 1 to 5. They are different modes of execution. Now, the last part is appeal. Okay. Now, here we are talking about the first appeals, and the provisions are going to be sections 96 to 99, and the order is order 41. Okay. So, whenever a decree is passed, the losing party wants to challenge it in the court of appeal. So the immediately superior court has to be approached, and that actually entertains the appeal. Okay? An appeal has not been defined, but yaad rakhna, under section 96, the general rule is that a decree is appealable. Right? General rule is a decree is appealable. Unless CPC says that it is not appealable. And it is not appealable. So, as a general rule, every decree is appealable unless CPC says that it is not appealable. Now, when we look at the question key, what do you mean by what is an appeal? Because that has not been defined in the Code of Civil Procedure. But ek baat yaad rakhna, the appeal is generally the re-examination of the decision of a lower court by the superior court. So whatever the decision has been given by the lower court, that is re-examined by the appellate court. Okay? Ab yaad rakhna, although every decree is appealable, but there are some decrees which are not appealable, like in section 96(3). Says a decree which is passed with the consent of the parties. I'm saying it again. A decree which is passed with the consent of the parties is not appealable. A decree passed with the consent of the parties is not appealable. That was just to give you an overview of the appellate process. Right? अब देखो इसमें we don't have time, but याद रखना थोड़ा सा review में देखो याद रखो, appeal is made to a superior court. Review is made to the same court which passed the decree or the order, right? 114 में लिखा हुआ है ये. And then revision is always made to the high court. याद रखना, there is no other court which can exercise the power of revision in CBC. CRPC में there's a different provision. Revision is only made to the high court. Section 115 में अगर जाओगे वहां पर revision to the high court दिया हुआ है. Review is made to the same court which passed the decree or the order. And appeal is made to the immediately superior court. Our time is over. Hey, do you have any questions? Do you have any questions? Karan? Anyone else? Do you have any questions? So तुम लोग पूरी class में चुप रहे except Karan. Karan was the only one who was interacting with me. बेटा तुम लोग को क्वेश्चन पूछने चाहिए थे या एटलीस्ट बोले थे कि सर ये नहीं समझ में आया, आप दोबारा बता दो. चलो खैर, वी आर डन विद द टाइम नाउ. ठीक है. थैंक यू करण, इट वाज वेरी नाइस इंटरैक्टिंग विद यू. थैंक यू एवरीवन.